from Macon. Hi, Mike.
Hello, how are you?
Hey, Mike.
Hi, Mike.
Hi, Mike.
Go ahead with your question.
Yes, I've got a rather unique situation here. I have a lease-purchase option home here. This all started back in January of 2006. One of the stipulations in my contract is I have to pay for the insurance on the, the policy on the property. After the tornado of 2008, they canceled insurance. I've been begging this lady that I've, leasing the house from to own, to get another insurance policy, and she absolutely refuses to. And not on my rights as far as that goes, because I'm basically told her I'm not going to pay any more payments until we so she gets an insurance policy on this home.
Okay.
I don't own it. I can't get an insurance policy.
Okay.
I missed the first part of what he said. What's the question?
The question is that I have a lease purchase.
Lease purchase.
Oh, lease purchase.
Okay.
Okay.
One of the stipulations in the contract is I pay the insurance policy.
But they've canceled.
After the tornado of 2008,
Okay.
the tornado.
Okay.
They canceled the insurance policy due to damage to the home.
Okay.
Now I've still got structural damage to the home. I've been asking the lady to get another policy. She says that I've got to do it myself. I can't. I don't own the property.
Okay.
Great question.
Okay. Renee.
That sounds like a good question. Well, since you have a lease purchase, I do want to go back to the original damage to the home. Was it ever repaired? Was the structural damage ever repaired from that 2008 damage?
And the frame of the home, the substructure, the main beams that go from the front of the house to the rear of the house are actually broken. That was not repaired. 3 of them. I went under the house, took pictures, everything else. She wouldn't cooperate with me or my attorney and the insurance company, and then they canceled the policy, and she just refuses to get an insurance policy on the home.
Okay. So.
Well, it actually sounds as if your lease purchase agreement has some terms in it that would benefit you. If you go through your lease purchase agreement, and it sounds like you already have an attorney you're working with, ask them if indeed the person that you're purchasing the home from is in breach of that agreement. If they are in breach of that agreement, then ask your attorney to represent you in either helping you to have the seller or landlord, in this case seller, comply with the terms of the lease. If they will not, then you may want to see what your rights are as far as, getting out of that lease purchase.
All right. Thanks for your question, Mike. Our next caller is Mark from Macon. Hi, Mark.
Hey, how you doing?
Doing well. Go ahead with your question.
I was living in an apartment complex about 2 years ago, and I slipped and fell, and I had to go to the doctor, and I accumulated some hospital bills, and I contacted the landlord on several occasions, and no one never really finally talked to me, and I accumulated some hospital bills, and I was just trying to see, did the statute of limitation run out for me to talk to someone to try to see can I get the hospital bills resolved?
Okay.
That's a good one. Do you want to take that?
Go ahead.
Personal injury.
2 years is a problem.
2 years is a problem, yes. I think we'd agree with that. Depending on how close you are to the date of your injury, it would probably be very difficult for you to bring a case if you are just before that 2 years. Your attorney wouldn't even have time to probably investigate well and to help you with recovering based on your injuries, but the statute of limitations for you would run out in 2 years.
Plus, a lot of times in the context of a landlord-tenant, the tenant, what causes the injury is something that they encounter every day. It might be a loose step or something of that nature, something they walk past, a sharp drop-off or something. They deal with it every day. And then when it finally hurts them, they want to file some sort of claim, and unfortunately the law doesn't allow that.
That's
if you
true.
knew it was there and just it injured you that particular day, if you'd successfully negotiated that before.
Okay,
Very
thanks
true.
for your question, Mark. This is the last person in our trio, because I thought it was a trio, Mike, Mark, Mary. This is Mary. Hi, Mary.
Hi, how you doing?
Doing well, Mary. Go ahead with your question.
Yes, I applied for apartment, and then lady wanted secure deposit. What is secure deposit? And if I do not get the apartment, can I get the secure deposit back?
Okay. What does a secure deposit mean, Mary? Okay.
A security deposit is something that a landlord will ask for at the start of your lease term. It is to help the landlord in covering any expenses that may come outside of your rent. Now, whether or not that security deposit is able to be returned to you is dependent upon your agreement with the landlord. So it's very important that you do one thing at the outset, that you read your lease and that you ask your landlord the question about that security deposit. If it's refundable, then it will be written in your lease that it is refundable. If your landlord would be able to withhold any portion of your security deposit, then your lease should set out the terms that would tell you why your landlord could hold back some portion or all of your security deposit. Okay?
Thanks for your question, Mary. Renee, I don't remember which one of the callers jogged my memory on this one, but just play devil's advocate. You've got 3 people, perhaps, on a lease and 2 skip out. Is that third person responsible for everything, or would they, would he try to go after the landlord? All 3, or?
If all 3 people are on that lease, then all 3 people are responsible. And if the other 2 dip out on you and you've got roommate situation, the one tenant that is left can be held responsible for the entirety. If they're still staying in that apartment, then the landlord is still due the full amount of the rent for that apartment, whether it dwindles down from 3 to 2 to 1.
Okay.
Opinions expressed on Law Call are those of the participants and do not necessarily reflect the opinions of 13 WMAZ staff or management, nor any legal or judicial entity. The legal information supplied in this broadcast is general information only and is not intended to be legal advice for any given situation. Do not rely on broadcast information without consulting an attorney. Contingent attorney's fees refers only to those fees charged by the attorneys for legal services. Such fees are not permitted in all types of cases. Court costs and other additional expenses of legal action usually must be paid by the client.